patent sucks because you didn't know the difference between a design patent and a utility patent. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. In the US, there are three kinds of patents. I'm only going to talk about two of them in this video. The three kinds are plant patents, design patents, and utility patents. A plant patent protects the asexual reproduction of plants. I've never gotten one. I don't know the process, honestly. I just know it exists. A design patent protects the ornamental appearance of an article of manufacture. It protects the aesthetic features, the way it looks. A utility patent protects the structure and function of machines, articles of manufacture, compositions of matter, and processes. You can definitely have an invention that has both aesthetic features and structural and functional features that you want to protect. In fact, during the smartphone wars in the mid-teens, both Samsung and Apple launched a volley of patents at each other, design patents and utility patents that covered various features on smartphones. So you definitely can do it. And I'm going to show you an example of a very simple invention that is covered by both a design patent and a utility patent. So it's really important to know what you're trying to protect. You cannot protect functional features with a design patent. You cannot protect aesthetic features with a utility patent. As you'll see, a design patent is a simple document. It's a set of drawings, a one-line claim, and a list of what the figures are. And a utility patent is what people commonly associate with being a patent. It's got drawings, a written specification, and written claims. The thing with a design patent that you have to be very careful of is that because it's aesthetic, the drawings you supply need to be sufficient to reproduce the object's appearance in 360 degrees. That means that you have to show all the different views and top and bottom, or you can sometimes say that the bottom's identical to the top or something, but you have to have a description that gives you all the views all the way around it. And more importantly, the views have to be consistent with one another. And that's where you can run into trouble, because if there's an inconsistency, it can be fatal in a design patent. Sometimes it's non-fixable. When I started prosecuting, because I litigated first, and then I moved into prosecution, and then I kind of moved back into a hybrid of prosecution and litigation. But when I started prosecuting, I was responsible for a bunch of shoe cases. So these were like pretty popular sneakers at the time in the early 2000s. And a shoe is a very non-linear object. And so it is really easy to have inconsistencies in the different views. You know, like if you're looking at a view one way, you'd say, okay, I expect to see this feature if I now look at it another way. And if you look that other way and you don't see it, then it's an inconsistency. And that can cause the claim to be deemed unpatentable for indefiniteness and for lack of enablement. And sometimes there's no way to fix it without adding what's called new matter to the application. And then it's dead. You just got to file it again. So getting the drawings right is super important. Now, in general, a design patent's a lot cheaper to get because really you're just supplying drawings. But you do have to have that accuracy in the drawings. And I remember once we switched drawing vendors and they could not stop fucking up these drawings. And finally I had to get rid of them. The guy I worked for thought they were cheaper. And I'm like, look, they're costing a fortune in time correcting all their fuck ups because they weren't good at it. So it does take somebody who's skilled at doing those drawings and maintaining that consistency 360 degrees around the object. Now, one thing is that you really got to know what you're trying to get and why you're trying to get it. I remember when I started prosecuting, there was some invention submission company that, put ads on late at night, told you to submit your invention and we'll get you a patent. And what they did is they got people design patents. What they wanted and needed were utility patents. And like I said, they're a lot cheaper to get. And so these people thought they had, gotten a utility patent and they didn't. So there has been a scam based on this difference. So let's go take a look at a very simple object, a scoop spatula, that is the subject of both a design patent and a utility patent. So this is a U.S. utility patent, and as opposed to a design patent, when you look in the upper right-hand corner, the patent number does not have a D, as in dog, prefix next to the number, and it doesn't have a suffix with an S. It's got one with a B as in boy. So that's how you tell, based on the patent number, the difference between a utility patent and a design patent. Now, in terms of the substance, the biggest thing is that a design patent won't have a specification that's written other than a really short description of drawings on the face page. So like this is one part of the specification. If you look at the right-hand column 2, there's a list of figures underneath that. That's basically the whole specification of a design patent. Just have that in the drawings. And of course, in the utility patent, we have these claims at the end, and you don't have that in a design patent. In a design patent, what you have is just a single claim that is for what is depicted in the drawings, basically. But this is a utility patent we're looking at now. Now, for this particular invention, it turns out this inventor also got a design patent for the same thing. So this is a design patent for the same scoop spatula. Now, as I said, if you look in the upper right-hand corner, you'll see the patent number has a D as in dog prefix. You'll also see that even though it only issued less than 2 years ago, it's only the 1,036,192nd design patent, because there's a lot fewer design patents than utility patents, and there's an S suffix in the design patent number also. Now, as I mentioned, in a design patent, you don't have a set of claims at the end, but you have a single claim, and you'll see it's on the face page in the right-hand column. It just says the ornamental design for a scoop spatula is shown and described. And that's basically all a design patent claim is ever going to be, which is just a reference to the drawings. Sometimes there's a thing called a broken line statement that will tell you that things shown in broken lines are not part of the claim. They're there for things like the environment that are not claimed. And then the specification really is just this description in the right-hand column on the face page. That's a list of the drawings. It corresponds to what we call the brief description of the drawings in a utility patent. So that's what a utility patent and design patent looks like, and how they differ from one another. And as you can tell by this particular example, yes, it is indeed possible to get both a design patent and a utility patent for the same item, but the scope of protection is very different. Now, one of the keys with design patents is you cannot protect functional features with a design patent. So you can't try to put some functional feature in the drawings and then stop somebody from using it because you have a design patent. They filter out for that in the infringement claim construction process in a patent lawsuit. So bearing that in mind, if you do what this scoop spatula person did and you get a patent on both the appearance and the structure and function, it's really important to be careful what you say in the utility application, because if you describe things as functional, that can be held against you with the design patent. Now, in the US, we examine design patent applications for novelty and utility. That's really not true, I think, in almost any foreign country I've dealt with, certainly not Europe. In a lot of places, they have a design registration system, which means all they do is make sure that all the formal information is right about the inventors and the drawings, but they don't compare it to the prior art. All the stuff about novelty and obviousness, that gets hashed out in litigation as opposed to having an examination process first. So what happens is it's a lot easier to get a patent, a design registration, much more quickly in a foreign country than it is to get a design patent here, just because they don't have examination processes. Okay, so that's design patents versus utility patents. I hope that helps keep you out of trouble, and I hope to see you here soon.